Hello to those watching and welcome to 3PB Employment and Discrimination Group's case law update on the 5th of June 2020. My name is Sarah Bowen. I'm a specialist employment and discrimination law barrister at 3PB. I am joined by my charismatic and knowledgeable colleague Grace Nicholls, who is also a specialist employment and discrimination law barrister. Detailed articles to support this webinar were published on the 4th of June in our monthly newsletter, which was edited by Grace and is available for you to read at your leisure. The newsletter also includes a guide to the main issues linked to COVID-19, including the Coronavirus Job Retention Scheme, the second Treasury Direction, statutory sick pay and annual leave, an article on health and safety and whistleblowing during the COVID-19 pandemic, changes to terms and conditions and redundancies, particularly in relation to the COVID-19 pandemic, and a summary of 3PB's experience of the Virtual Court of Appeal by Matthew Curtis. We will give you a whistle-stop overview of 4 recent appellate decisions, which we hope you will find both helpful and interesting. Full articles on these cases are contained in the newsletter. Hi, Grace.
Hi, Sarah.
What's the first case you're going to be looking at?
So the first case today is Williams and Alderman Davis Church in Wales Primary School.
So what was the issue in that case?
The salient take-home from this case is the correct approach to adopt in last or constructive dismissal cases.
What were the relevant facts?
This is an EAT decision on appeal from the Cardiff Employment Tribunal. Claimant's appeal to the EAT was heard by His Honour Judge Albach, and the facts of the case are as follows. The claimant was a teacher and had worked for many years at the respondent school. He was suspended in April 2015 following allegation in relation to a child protection concern, although he wasn't given any substantive information about it. An investigation and disciplinary process commenced, which lasted for over a year. The claimant was signed off sick with stress in September 2015 and did not return to work. In October 2015, the claimant was made aware that the child protection matter concerned an allegation involving manhandling of a child. He wasn't provided with the name of the child nor the person who'd made the complaint. The claimant, shortly after being suspended, had downloaded a large number of documents from the school system and shared them with his trade union rep and a fellow teacher, Mrs. S. Mrs. S was subsequently made subject to an investigation of her own about alleged breaches of the data protection policy. The claimant raised a grievance in November 2015. He was resuspended and a second disciplinary process commenced on data protection grounds in relation to the downloading of the material. He contended that this would have given his trade union a better picture of what he alleged was very poor treatment leading up to his suspension. Over a year and a half after he was originally suspended and following the grievance and grievance appeal, and now on the eve of the disciplinary process commencing, the claimant asked for further details in respect to the child protection matter, similar to what had been asked for before. This was declined by the respondent. The claimant resigned in June 2016, citing his reason for resigning as being that he'd received communication from his solicitor that Miss S was not allowed to contact him.
So Grace, what happened in the employment tribunal?
Well, the claimant pursued claims of constructive unfair dismissal, discriminatory constructive unfair dismissal, and a number of disability discrimination complaints. For the purpose of this podcast, I'm only going to focus on the ordinary constructive unfair dismissal issue. At the ET, a finding was reached that the last straw action of being told that Miss S wasn't permitted to contact him was sufficiently innocuous that it could not contribute to the ongoing actions of the school. The tribunal concluded that the claimant did not resign in response to a breach of the implied term of mutual trust and confidence.
The matter was appealed to the Employment Appeals Tribunal. What did that decide?
The claimant appealed on a number of grounds, but significantly for present purposes, that the tribunal had erred in finding that he had not been constructively unfairly dismissed. The EAT agreed with the claimant and held that the tribunal had erred in concluding that because they, the tribunal, had found that the conduct of the respondent, which had tipped the claimant into resigning, could not contribute to a breach of the implied term of mutual trust and confidence, that his claim of constructive unfair dismissal must fail. This approach, the EAT said, would only be correct if the tribunal had found that there was no prior conduct by the respondent amounting to a fundamental breach, or that the claimant had affirmed any breaches. If there was prior conduct amounting to a breach, which was not affirmed and which also materially contributed to the decision to resign, the claim of constructive unfair dismissal would succeed. The EAT therefore substituted its view, and a finding was made that the claimant had been constructively dismissed.
Well, the decision seems quite helpful for claimants in what is a particularly difficult area of law. What do you think, Grace?
Yes, I think I'd agree with you, Sarah. I think this case is a helpful restating of the position in respect of constructive unfair dismissal complaints, alongside the decisions in Lewis v Motor World Garages, Omology and Waltham Forest London Borough Council, and Kerr and Leeds Teaching Hospitals NHS Trust. Constructive unfair dismissal cases can be notoriously difficult to prove, and I think this case is a helpful map for those representing claimants. So Sarah, what's the first case you're going to talk about?
The first case is Duchy and Farm Kennels Limited.
And what were the issues in this case?
Well, the issue relates to confidentiality clauses in a COT3 agreement, and in particular, whether an employer can avoid paying sums in a settlement if the employee breaches a confidentiality clause.
What were the salient facts in Duchy?
Well, the claimant in this case brought claims against his former employer, a small business involved in the manufacture of dog kennels, for unfair dismissal. Following an ACAS conciliation COT3 agreement, the claimant was to be paid £15,000 in 47 weekly instalments, that's about £330 a week, in full and final settlement of his claims. A confidentiality clause was included requiring the parties to keep the fact and terms of the agreement strictly confidential, save for the usual caveats such as informing regulatory authorities or professional advisors. At the juncture of having paid the claimant £2,960, the employer alleged that the claimant was in breach of the confidentiality clause by disclosing the amount agreed in the COT3 to a former employee. Mr. Duchy issued a claim in the county court to enforce the remainder of the sum due under the COT3. His employer defended that claim on the basis that his breach of the confidentiality clause vitiated his entitlement to the remaining £13,000.
So Sarah, what did the county court decide in this case?
So Her Honour Judge Wall concluded that Mr. Duchy had breached the confidentiality clause. However, that was a breach of an intermediate term of the agreement rather than a breach of a condition. Therefore, it did not automatically release farm kennels from their obligations under the COT3. She concluded that the claimant's actions did not amount to a repudiatory breach of the agreement, and that his former employer was therefore still under an obligation to pay him in accordance with the aforementioned terms.
Perhaps unsurprisingly, Farm Kennels appealed to the High Court. What was the outcome of that?
Mr. Justice Kavanagh upheld the first instance decision and held that the COT3 had not expressly stated that the confidentiality clause was a condition, and that the breach of that condition would frustrate the guilty party's entitlement to the settlement sum.
Seems like an interesting case for employees and employers alike. What are your views on it, and what practical implications does it have?
It's interesting, isn't it? I mean, as you know, Grace, confidentiality clauses are standard, perhaps for both parties in a settlement agreement. Even where a clause is breached, usually the real issue is proving that the innocent party has suffered any damage that arises from that breach. However, there will be cases where this can be proven, perhaps, for example, if it leads to reputational damage, loss of clientele, or results in a flurry of claims from other members of the workforce. But the important point to take from this case is that the clauses always serve as a deterrent, but it's clear from this case that the wording of them in the agreements is exceptionally important. So that brings us to our third case, Grace. Which one would you like to talk about?
So the next case I'm going to discuss is Ferguson and others v. Australia Asset Management Limited.
So what was the legal issue in Ferguson?
The issue to be decided was whether contractual variations which are beneficial and advantageous to employees are void if they're created by reason of a cheapy transfer, and also the EAT was looking at the correct interpretation of regulation 4.4 of cheapy. which you should be seeing on your screens now.
Regulation 4.4 is there in the box. So Grace, what were the relevant facts in Ferguson?
So Ferguson involved 4 claimants who pursued claims originally in the London Central ET. Those claimants were Mr. F, Mr. K, Mr. L and Mr. P. Mr. F and Mr. K were employees of Lancer, and Mr. L and Mr. P were employed by companies who contracted their services to Lancer. All 4 individuals that I've mentioned were directors, and they were involved in managing the Berkeley Square estate, which is comprised of approximately 140 properties across Mayfair and Kensington, worth in the region of £5 billion. Astrea, a separate company, were subsequently appointed to manage the estate to commence in September 2017. And there was no dispute between the parties that there was a relevant cheapie transfer between Lancer to Astrea. In or around June 2017, the claimants decided to update their Lancer staff contracts of employment and review their own terms. They made their own terms significantly more beneficial. For example, Mr. K and Mr. F signed new contracts of employment dated the 26th of July 2017, which contained the following terms: new rights to guaranteed bonuses amounting to 50% of their salary, £576,000 and £402,000 respectively, and new contractual termination payments amounting to a month's salary for every year served as director of Lancer, said later to amount to £768,000 and £380,000 respectively, as at September 2017. Similar changes were made to Mr. L and Mr. P's contract, including an extension of the contractual notice period from 12 to 24 months. Those new contracts were provided to the respondent, Astrea, in early September 2017, after the provision of the employee liability information. In late September 2017, the respondent wrote various letters, one of which confirmed that Mr. K's employment would terminate with immediate effect by reason of gross misconduct in relation to the contracts, and that it was not accepted that Mr. L and Mr. P would transfer, but if they did, they would also be dismissed for the same reason. In relation to Mr. F, although he did transfer on the 29th of September 2017, he was dismissed for gross misconduct shortly after the transfer for his actions in relation to the new contracts.
Very, very generous terms. I'm not surprised it resulted in litigation. What was the decision of the tribunal at first instance, Grace?
So the claimants brought proceedings in the ET for unfair dismissal, contractual termination payments, and 13 weeks paid for breach of Regulation 13.4 of cheapie. The ET found that Mr. F had been unfairly dismissed, and his award was increased by 25% for failure to follow the ACAS code. And if you'll remember, Mr. F was the one who did transfer and was then dismissed shortly after the transfer. Mr. K was found to have been unfairly dismissed pursuant to Regulation 7.1 of cheapie because the reason for his dismissal was transfer, but any award that he was entitled to was reduced by 100% due to conduct, and the Polky was applicable in any event. In relation to Mr. L and Mr. P, Employment Judge Goodman found that there was no claim against the respondent as they were not assigned to a relevant grouping and therefore didn't enjoy protection under the regulations. Of particular note for the purposes of this podcast is that Employment Judge Goodman found further, in considering Regulation 4.4 of cheapie, in light of the abuse principle, the terms of the new contracts relating to bonus, termination payment and notice were in any event void because they were varied by reason of the transfer.
So that decision was appealed to the EAT. What was the outcome?
On appeal to the EAT, His Honour Judge Shanks explored and analysed the correct interpretation of Regulation 4.4 of cheapie. And by way of a reminder, of course, you have just seen this on your screen, but the key point is any purported variation of a contract of employment that is or will be transferred by paragraph 1 is void if the sole or principal reason for the variation is the transfer. Now, the claimants before His Honour Judge Shanks sought to argue that the variations referred to in Regulation 4.4 must be read as only referring to adverse variations to an employee. And of course, they were trying to protect variations that were advantageous to them in these circumstances. His Honour Judge Shanks's view was that applying the broad purposive approach to its interpretation, the words any purported variation in Regulation 4.4 should be construed to cover all types of variation, so positive and negative variations, not just those that were adverse to the employee as proposed by the claimants. He went on to hold that the EU abuse of law principle was satisfied, namely that EU law cannot be relied upon for abusive or fraudulent ends, and that the employment judge at first instance had reached an implicit conclusion that the claimant's case in relation to the new contractual terms involved an abuse of EU law. Therefore, in relation to both the contractual interpretation of Regulation 4.4 and the EU abuse of law argument, the claimant's appeal on this ground was bound to fail.
It's a very interesting case because of the nature of the variation. Have you got any further thoughts on this case from a practical point of view?
Yes, Sarah, I think this case is potentially novel on its facts, but it'll be very interesting to see if this case goes on appeal to the Court of Appeal and any divergence in the interpretation by higher courts of Regulation 4.4, and of course, what we were all thinking about before the current period of time, Brexit, and any implications that that has on this decision.
Yes, it's been quite nice to have a break from Brexit, although perhaps not in the circumstances. Right.
So Sarah, what's the last and final case you're talking about?
So the last case is East Coast Mainline Company Limited and Cameron, which was the AT decision, sorry.
Okay. And what were the issues in that case?
This case involves consideration of wrongful dismissal. An employer may dismiss without notice where an employee has committed a repudiatory breach of contract, of course. The issue in Cameron was whether an employee's length of service is relevant to the question of whether they have been wrongfully dismissed.
What were the facts in Cameron?
So Mr. Cameron had been accused of negligence in authorising the departure of a train by his employer. Another train driver standing between that departing train and his own had been brushed by the departing train. This resulted in a significant safety incident. An investigation concluded that Mr. Cameron had not completed adequate safety checks, and he was summarily dismissed and then brought claims both for unfair dismissal, discrimination and wrongful dismissal.
What did the ET find in this case?
So in the tribunal, in deciding whether or not Mr. Cameron had committed a repudiatory breach of contract, thus justifying dismissal without notice, it took into consideration his 35 years of experience. Weight was given to that lengthy service in deciding whether his conduct undermined the trust and confidence between the parties, or whether it was a one-off decision made in confused and muddled circumstances. The tribunal concluded that Mr. Cameron was in fact wrongfully dismissed.
The employer appealed that decision. What did the EAT decide?
That length of service has no bearing on the question of how serious a breach of contract is. Even though they reached that conclusion, the EAT also, in the alternative, found that if they were wrong, that the decision in this particular case to hold his 35 years of service in his favour was perverse on the facts, and in fact it should have been held against him because it should have enabled him to carry out his job to the required standard. The incident could have been catastrophic, and Mr. Cameron was not remorseful.
What comment have any of you got about this case, Sarah, and any relevant authorities?
So the EAT in this case applied the principles as set out in the Des Soken, which will appear on the screens now. Those principles are guidance as to how to determine when conduct is gross. The tribunal must ask itself whether the misconduct can properly be described as gross. This is a question of fact. The focus is on the damage to the relationship between the parties. Dishonesty and other deliberate actions which poison the relationship will obviously fall into the gross misconduct category, but so in an appropriate case can an act of gross negligence. In negligence cases, the key is whether the EAT applied the principles set out in Adesoken and Sainsbury's supermarkets in determining when conduct is gross misconduct. A tribunal must ask itself whether the misconduct can properly be described as gross. This is a question of fact. The focus is on the damage to the relationship between the parties. Dishonesty and other deliberate actions which poison the relationship will obviously fall into the gross misconduct category, but so in an appropriate case can an act of gross negligence. In negligence cases, the key is whether the negligent dereliction of duty is so grave and weighty as to amount to a justification for summary dismissal. The fact that there was no harm caused by the negligence is not in itself a mitigating factor. Length of service, therefore, we can take from the present case of Cameron, is clearly not a safety blanket for employees. So finally, Grace. On Monday evening, the presidents of the Employment Tribunals for England, Wales and Scotland released joint guidance and the roadmap for recovery in respect of the employment tribunals during COVID-19. Can you summarise what was said?
Of course. So many of you will be aware of the joint updated guidance. The links to this can be found within the newsletter, and I strongly urge practitioners, if you've not already done so, to reread the updated FAQs because they are incredibly important. At Appendix 1 of that document, the presidents set out a proposed roadmap for listings and hearings from June to December 2020. It's of course stressed within that document and generally that it's a roadmap and not a definitive statement of intent, and it's contingent on a number of factors far beyond judicial control. The roadmap highlights the following key things which I wanted to bring to your attention. Firstly, that there's likely to be an increase in staff availability in various regional ET offices. Secondly, an improved means to conduct CVP hearings. A licence, we are told, has been obtained for 150 hearing rooms. There's going to be a categorisation of cases, so 3 types: short track, which are likely to be cases such as redundancy payments, notice pay and holiday pay; standard track, involving ordinary straightforward unfair dismissal; and open track, where issues of whistleblowing and discrimination need to be determined. So for June 2020, the focus is going to be on continuing remote hearings with priority jurisdictions for things like applications for interim relief, dismissals where accommodation is linked to an employee's work, COVID pandemic related allegations of detriment and dismissal, so for example on health and safety grounds or protected disclosures. The emphasis in June will be on CVP and telephone hearings. It's unlikely that standard and open track hearings will be heard even remotely in June, and there's likely to be more training for staff in the judiciary during this month. In July and August, there will be some standard track cases by CVP, and of course, referring back, the standard track is unfair dismissal. There's likely to be an increased number of fee-paid employment judges. There'll be some in-person hearings, and we're likely to see a hybrid of witnesses appearing via CVP and lawyers appearing in person. There'll be training of non-legal members in CVP, and we're unlikely to see any open track cases in July and August. By September and October of 2020, we're likely to see some open track cases happening with a range of options for appearing either entirely in person, but of course this is likely to be relatively few due to social distancing measures, hybrid in-person and CVP hearings, as I've discussed earlier, or hearings taking place wholly via CVP. And then in November and December 2020, there's likely to be a period of consolidation and review of all of the lessons that have been learned over the past period of months and how we move forwards from there.
Interesting. Fingers crossed, I think, over the next few months. They're certainly trying to get things moving now, but there's obviously a massive backlog, isn't there? So that concludes our first case law summary via webinar. And that leaves me to say thank you very much on behalf of Grace and I for virtually attending today. We hope that you found it useful. To sign up for invitations to our webinars or to receive our newsletter, please contact Russell Porter using the following links. Thank you. Goodbye.